She planned these murders, gave herself the time and privacy needed to commit the murders, and then she strangled each child in the place where they should have felt the safest, at home with their mom.
This is not a situation, Your Honor, that was planned by any means. This is a situation that clearly was a product of mental illness.
That is the prosecution and the defense at the 2023 arraignment of Lindsay Clancy. She's the former labor and delivery nurse who is accused of murdering her 3 young children at their home in Duxbury, Massachusetts. That's a coastal suburb of Boston. Lindsay attended the hearing remotely via video conference from her hospital bed, where she was recovering from injuries she sustained on the night of January 24th, 2023.
By Tuesday, closing arguments could begin in the trial of Lindsay Clancy. Sit with that for a second, because it means something specific. 5 weeks of testimony, more than 70 witnesses for the prosecution alone. Autopsy testimony so difficult, the judge has stopped this trial more than once, just to let the jury breathe. 5 weeks, and by this time next week, 12 people may already have an answer. Here's what I need you to understand before we go any further, because it's the part almost every headline about this case gets backwards. Nobody in that courtroom is arguing about whether Lindsay Clancy killed her 3 children. She admitted as much to police the night it happened, and per 3.5 years of hearings since, she has never once disputed it. Not at arraignment, not for a single day of this trial. So if that's not the question, what is? Here it is, and I want you to hold on to it, because everything we cover from here circles back to this one point. In the specific minutes it took to strangle 3 children, one at a time, in the basement of her own home, did Lindsay Clancy understand that what she was doing was wrong? Could she have stopped herself? That's the whole case. Not who did it, whether the woman who did it was capable, under the law, of choosing not to. Getting a jury to that question took cell phone forensics. It took a psychiatrist who once testified in the most infamous postpartum psychosis case in American legal history. It took a crisis line that turned a drowning woman away twice. And per prosecutors, it took something as small as a restaurant search on a mapping app. One data point, they say, proves she planned every minute of what happened next. We're going through all of it, but not yet. Because before the searches, before the psychiatrists, before the arguments you're about to hear repeated on every legal channel this week, I want you to know who Cora, Dawson, and Callan Clancy actually were. It matters, and somewhere across 5 weeks of trial coverage, it's gotten lost. This case carries their mother's name. Let's not let the 3 of them disappear into it. Cora was 5, the oldest, and per the people who loved her, the spark of the family. Her father has described her laugh as infectious, the kind that fills a room before you even know what's funny. She loved to dance. She loved being outside. And per accounts from those closest to the family, Cora had already stepped into the role of big sister, looking out for her 2 younger brothers, with the kind of seriousness 5-year-olds usually save for their favorite games. Dawson was 3. His father remembers his eyes first, bold, brown, the kind that beamed with friendship, he said, which is exactly the sort of detail that only makes sense once you've watched a 3-year-old actually look at you like that. Dawson was at the age where every day is new, endlessly curious, still small enough to be carried, and just old enough to insist he didn't need to be. And Callan was 7 months old, the baby of the family, born into a household that, from the outside, looked like it was thriving. A mother who'd spent her career delivering other people's children, a father, 2 older siblings already wrapped around him. Per the people who knew him, he was constantly smiling, vibrant, the kind of infant who made grown adults perform just to see him laugh again. He had been alive for 7 months. He did not get an 8th. Say that slowly. 5 years old, 3 years old, 7 months. Those are the 3 people this case is actually about, not the psychiatric terminology, not the legal standard about to get argued in a Plymouth courtroom this week. 3 kids who are gone, and who are going to stay gone no matter what a jury decides. Which brings us to how it happened, And to understand exactly where this trial stands right now, on the edge of closing arguments, you have to go back to a single Tuesday evening in January of 2023, to a woman who, per nearly everyone who knew her, had already been asking for help for months. Lindsay Clancy was 32 years old on the evening of January 24, 2023, and for most of her adult life, she had built a career around exactly the kind of care she would, hours later, be accused of destroying. She was a labor and delivery nurse, someone who spent her working life bringing other people's children safely into the world. Per everyone who worked alongside her, she was good at it. That Tuesday looked, by every outward measure, like an ordinary one. Patrick Clancy, her husband at the time, though we'll get to why that matters later, left the house that evening to run 2 errands, a stop at CVS for medication for one of the kids, and a stop for takeout at a restaurant called 3V, a little further from home than the place the family usually ordered from. Per phone records read into evidence at trial, at 4:13 that afternoon, Lindsay's phone was used to search 3V on Apple Maps. Not long after, just before 5, she texted Patrick, asking if he wanted to grab dinner there instead of somewhere closer. Ordinary, forgettable, the kind of text 100,000 households send on any given Tuesday. Except that, per the Commonwealth, that text and that search are 2 of the most important pieces of evidence in this entire case. We'll get to exactly why in a moment. What happened next is not in dispute. While Patrick was out of the house, Lindsay Clancy went to the basement, where her 3 children were, and killed each of them by strangulation, using a set of exercise bands. I'm not going to speculate on the order, because that's a detail neither side has settled publicly, and speculating on it teaches you nothing except how a detail like that can make an already unbearable story feel even more unbearable. After the children were dead, Lindsay went to the second story of the house and fell, by her own account and the Commonwealth's, in an attempt to end her own life, from a bedroom window. Per medical testimony at trial, the fall broke her spine, including a fracture at the very top of her vertebral column, the kind of injury that, survived, tends to leave a person permanently paralyzed. It left Lindsay Clancy paralyzed from the waist down. She has used a wheelchair ever since. Patrick Clancy came home to find her on the ground outside the house. Per his own 911 call, played for the jury earlier in this trial, he can be heard going inside, finding his children, and screaming 4 words into the phone, "She killed the kids." Cora and Dawson were pronounced dead at the hospital that night. Callan, the baby, held on for several days at Boston Children's Hospital before he died from his injuries too. In the days that followed, this stopped being a private tragedy and became a story that moved through national news coverage. A vigil formed in Duxbury within days. A fundraiser, organized by Patrick, raised support for the family. And within weeks, a grand jury had indicted Lindsay Clancy on 3 counts of murder and strangulation. What followed was 3.5 years of delays, most of them procedural rather than dramatic, but worth understanding because they explain why a case from January 2023 is only now reaching a jury. Per court filings, the defense needed time for a government-ordered psychiatric evaluation, consultations with a toxicologist and a psychopharmacologist to untangle the medication history, and the preparation of substantive pretrial motions. The trial date moved more than once, pushed later each time so both legal teams could actually be ready, until it finally began this past July. That is the undisputed core of this case. A mother, 3 children, one evening in January. Nothing about that paragraph has been contested for 1 minute of this trial. Everything else, every witness, every expert, every piece of digital forensics you're about to hear about, exists to answer one question about that undisputed core. Not what happened, why, and whether, in the eyes of the law, Lindsay Clancy is responsible for it. When Assistant District Attorney Shannon Buckingham stood up to deliver the Commonwealth's opening statement, back in July, she didn't waste time easing the jury into her theory of the case. Per her opening, she called Lindsay Clancy extremely controlling, meticulous, and manipulative. She told jurors the days leading up to January 24th were laid out with specificity, and she said Clancy acted deliberately and meticulously, that whatever mental health struggles she'd had, she was not, in Buckingham's words, in the throes of psychosis when she killed her children. That's the entire shape of the prosecution's case, and everything they've built since is in service of that one sentence. This wasn't chaos. This was control. Here's why the Apple Maps search matters so much to that theory. Per Trooper Timothy Chiappini, the state police digital forensics investigator who spent the better part of a day on the stand walking jurors through Lindsay's phone, that 4:13 p.m. search wasn't random. Prosecutors argue it was reconnaissance, a woman calculating exactly how long a trip to a restaurant would take, so she'd know exactly how long she had. And per the Commonwealth, the choice of 3V over a closer, more familiar option wasn't taste, it was math. A farther restaurant means more minutes. More minutes means more time. Then there's the phrase that, per courtroom reporters, made an entire gallery go quiet when Chiappini read it aloud. 3 days before the killings, someone searched Lindsay Clancy's phone for the words, "Can you treat a sociopath?" Sit with that for a second, because I promise you, both sides are going to make you sit with it very differently before this trial is over. For the prosecution, that search is close to devastating. It suggests a woman who, days before she killed her children, was thinking in exactly the clinical, self-aware terms a person in the grip of psychosis typically isn't capable of. It suggests insight. It suggests someone watching herself from the outside and asking, in effect, what am I capable of? There's also a set of searches from Lindsay's phone that don't fit neatly into either side's story, and I think it's worth being honest about that instead of smoothing it over. Per forensic analyst Ian Whiffin's testimony, Lindsay's search history in the weeks before the killings included queries like how quickly Wellbutrin works for depression and whether ketamine can help with suicidal thoughts. Prosecutors haven't leaned on those searches to argue premeditation of the murders. They don't fit that argument. If anything, they're closer to the defense's version of events, a woman searching, on her own, for anything that might make the inside of her head feel different. It's a reminder that the evidence in this case doesn't sort itself cleanly into prosecution facts and defense facts. Some of it just sits there, belonging to both arguments and neither. Per Whiffin's testimony, Lindsay's phone was last unlocked at 5:13 that evening, just before Patrick would have arrived at the restaurant. Text exchanges from earlier that day show her asking about dinner, mentioning Callan's nap schedule, sounding, on the page at least, like someone having an entirely normal Tuesday. None of this digital evidence came out of nowhere. Per testimony from Massachusetts State Police Sergeant Dan Lawler, investigators moved quickly in the hours after the killings, collecting Lindsay's clothing and her wedding band from the hospital where she was first treated, executing a search warrant at the Duxbury home, and documenting pill bottles found in the kitchen. Separately, per testimony from Sergeant Kyle Pavao, investigators pulled data from a laptop found in the basement, the same room where the children were killed. Cross-referenced against the phone records, that's how the timeline prosecutors walked this jury through, piece by piece, over multiple days of testimony, actually got built. Prosecutors have gone even further than the phone evidence, questioning whether Lindsay Clancy's own suicide attempt fits the pattern of chaos the defense describes. At her arraignment, years before this trial began, Assistant District Attorney Jennifer Sprague suggested to the court that Clancy hadn't necessarily intended to die that night at all, that per Sprague's characterization, she lowered herself out of the window rather than simply jumping, which Sprague argued was inconsistent with a genuine attempt to end her life. It's a detail the defense has pushed back on hard, given the spinal fracture and permanent paralysis that resulted either way. But it shows you how far each side is willing to go to make even the most devastating parts of this story fit their version of who Lindsay Clancy was in that moment. There's one more piece of digital evidence worth understanding, because both sides have reached for it too. Investigators recovered a note from Lindsay's phone written months before the killings, where she described feeling anxious, asked a psychiatrist about starting a new medication, and admitted, in her own words, that this was when everything started going downhill for her. For the defense, that note is a real-time record of a woman watching herself deteriorate. For the prosecution, it's evidence that she was capable, the whole time, of putting her own mental state into words, of narrating it, tracking it, understanding it. Same document. Two completely different arguments. You're going to see that pattern again and again in this case, and it's worth getting used to now, because it's the entire trial in miniature. And that's the prosecution's real argument, underneath all the individual pieces of evidence. Not that any single search or text proves premeditation on its own, it's that none of it, not one search, not one text, not one decision that day, looks like a woman who had lost touch with reality. It looks, prosecutors say, like a woman who understood exactly what she was doing and did it anyway. There's a legal reason this matters more than it might seem to on the surface, and I want to explain it now so the rest of this makes sense. In Massachusetts, once a defendant raises an insanity defense, the burden doesn't sit with the defense to prove she was insane. It sits with the prosecution to prove, beyond a reasonable doubt, that she wasn't. Every text, every search, every ordinary-sounding sentence Lindsay Clancy typed that day is a brick in that wall, because the prosecution doesn't need the jury to believe she's a monster. They need the jury to believe she understood right from wrong, and that she could control what she did about it. That's it. That's the whole legal fight, dressed up in phone records. If the Commonwealth's case is built on the idea that nothing about that Tuesday looks like psychosis, the defense's entire case is built on everything that happened in the months before it. Kevin Reddington, Clancy's defense attorney, told the jury in his own opening statement that Lindsay Clancy was suffering from psychosis when she killed her children. Full stop, no. Hedging. His job since then hasn't been to argue about whether she did it. It's been to walk this jury, witness by witness, through a decline that, per the defense, almost everyone around her saw, and almost no one caught in time. Start with the medication. Per medical testimony and court filings, in the 4 months before the killings, Lindsay Clancy was prescribed 13 different medications by at least 3 separate providers as they tried to treat symptoms that kept shifting and kept getting worse. About a month before she killed her children, per her ex-husband's own testimony, she spent time as an inpatient at McLean Hospital, one of the most respected psychiatric facilities in the country, for treatment. Here's a piece of testimony that complicates the over-medication narrative in an interesting way, and I think it's worth including precisely because it doesn't neatly support either side. A toxicology expert who testified for the defense told the jury that, per their analysis, the actual drug levels in Lindsay's system at the time were low, not dangerously high. That doesn't undercut the argument that 13 medications in 4 months, from 3 different providers, represents genuinely chaotic, poorly coordinated care. But it does complicate any simple story where over-medication alone explains what happened. Whatever was going on in Lindsay Clancy's mind by January, the toxicology evidence suggests it wasn't simply a drug reaction. It was something else, layered on top of, or maybe underneath, the medication chaos. And here's where it gets genuinely hard to sit with. Per testimony from a clinical forensic psychologist named Dr. Paul Zeisel, Lindsay Clancy called a crisis line, a service called Aspire, on December 4, 2022, 7 weeks before the killings. She was turned away. Per Zeisel's testimony, she didn't meet the standard of care because she didn't have a specific plan to hurt herself. She called again days later. Per that same testimony, she was turned away a second time for the same reason. Twice, a woman who was, by the account of her own psychiatrist, her mother, her mother-in-law, her co-workers, visibly unraveling, reached for the exact kind of help that exists specifically to catch people like her. And twice, per the testimony this jury has heard, the system told her no. It gets worse before it gets better, because per Dr. Zeisel's account, Reddington's own witness list forced an uncomfortable admission out of Dr. Jennifer Tufts, the psychiatrist who treated Clancy in the months before the killings. Tufts admitted on the stand that she never once asked her patient about those crisis line calls, never asked if she was still having thoughts of harming herself, never asked about suicide hotlines at all. This isn't a story, the defense argues, about a woman who hid what was happening inside her. It's a story about a woman who kept telling people something was wrong, in every way the system gives a person to say it, and kept not being heard. Per Zeisel's testimony. By January, what Lindsay Clancy was experiencing had moved past depression and into something categorically different, paranoia, and eventually a male voice in her head ordering her, in Zeisel's account, to kill her children and then kill herself. I want to pause here because there's a detail from later in the trial that I think explains, better than any clinical term could, what the defense means when they talk about psychosis breaking someone's understanding of their own actions. A hospital chaplain named Sheila Kavanaugh, who sat with Lindsay Clancy in the days after the killings and testified that she developed a real bond with her, told the jury that Clancy said something to her, that she was glad her children were safe now. I'm not including that to shock you. I'm including it because it is, in a single sentence, the entire defense argument. Nobody, in any ordinary state of mind, believes killing their children makes those children safe. But per how forensic psychologists have explained cases like this one for decades, that is exactly the kind of delusion psychosis can produce. A break severe enough that the brain doesn't just misjudge a situation, it inverts it. Protection and destruction stop being opposites. If Lindsay Clancy actually believed, in that moment, that she was saving her children from something worse, then the legal question stops being about whether what she did was terrible. Nobody disputes that. It becomes about whether she was capable, at that moment, of knowing it was terrible at all. The defense hasn't relied only on experts to make that case. Clancy's own mother, Paula Musgrove, testified that her daughter had wanted to be a mother for as long as she could remember, and described watching her spiral into something unrecognizable in her final weeks. Per Musgrove's testimony, Lindsay kept telling her this wasn't her, that she'd never been like this before, and her mother agreed, because she hadn't. Per her former mother-in-law's testimony, Lindsay spent those same weeks begging for help. Per the family's nanny, who spent more time in that house than almost anyone outside the immediate family, she saw a wonderful mother, deeply attentive to her children's safety, right up until the end. And per Dr. Philip Resnick, the forensic psychiatrist who testified as the defense's final witness, and who, decades earlier, evaluated Andrea Yates in the case this one gets compared to constantly, Lindsay Clancy was very likely experiencing a manic episode consistent with bipolar disorder at the time of the killings, on top of the psychosis he believes had already taken hold. Not every expert who examined her agrees on the specifics. A separate forensic psychiatrist, Dr. Donald Condy, criticized Clancy's medical providers for never running basic blood or thyroid tests that might have caught a physical cause for her symptoms, but per his own testimony, he also confirmed that Clancy never reported hearing voices to any of her doctors before the killings, which is a detail prosecutors are almost certainly going to use in their closing argument. It's worth sitting with, because it's a reminder that this defense isn't one clean, unified story. It's several experts, largely agreeing on the broad picture, disagreeing on pieces of it, which is exactly what real psychiatric evidence usually looks like, messy edges and all. If you or someone you know is struggling with thoughts of suicide or self-harm, the 988 Suicide and Crisis Lifeline is free, confidential, and available around the clock by call or text. It costs nothing to reach out, and per everything in this trial, reaching out even once can matter more than anyone around you realizes. All of that, the medications, the crisis line, the voice in her head, exists to answer one specific legal question. So let's talk about what not criminally responsible actually means, because I guarantee you it's not what most people watching this trial assume. Legal insanity has nothing to do with a diagnosis. Roughly 90% of people currently sitting in American prisons have some form of diagnosable mental illness. That alone has never gotten anyone acquitted of anything. What the law actually asks is much narrower and much harder to prove either way. At the specific moment of the act, did the person understand the difference between right and wrong, and could they control what they were doing about it? Different states test that differently. A lot of states still use something called the Premeditation rule. Old, rigid, English in origin, and built around a single question: did the defendant know right from wrong? Massachusetts uses something more modern, called the substantial capacity test, and it asks two separate questions instead of one. Did the person appreciate the wrongfulness of what they were doing, and did they have the capacity to conform their behavior to the law? Here's the part of this that I think gets lost in almost every conversation about this case online. In Massachusetts, the burden of proof sits with the prosecution, not the defense. Once a defendant raises an insanity defense with some evidentiary support, which Lindsay Clancy's team cleared a long time ago, the Commonwealth has to prove, beyond a reasonable doubt, that she was not legally insane. Not the other way around. The defense doesn't have to convince this jury Lindsay Clancy was insane. The prosecution has to convince them she wasn't. That's a meaningfully higher bar than most true crime commentary about this case seems to give it credit for. Which brings us to the question that's been asked constantly, both inside this trial and across every comment section covering it. If Lindsay Clancy was clear-headed enough to search a restaurant on a map, time an errand, and send coherent texts about dinner, how can she also have been psychotic enough not to understand what she was doing? It's a fair question, and the answer is the single most important idea in this entire case, so I want to spend a minute on it properly. The case that comes up constantly in this context is Andrea Yates, Texas, 2001, a mother who drowned her 5 children in a bathtub, one at a time, in ascending order by age, so that each child could see what had happened to the one before. Andrea Yates planned. She waited until her husband left for work. She knew roughly how long she had before anyone else was expected home. Days earlier, she had been running water in that same bathtub, a dry run, in the most literal sense. That is organized, sequential, deliberate planning by any definition. And a Texas jury still found her not guilty by reason of insanity on her second trial, after psychiatrists, including Dr. Philip Resnick, the same expert who evaluated Lindsay Clancy, explained why. Here's the mechanism. Someone deep in psychosis isn't necessarily incapable of organizing a sequence of actions. What they're incapable of is understanding those actions correctly. Command hallucinations and delusions don't announce themselves as delusions. They arrive feeling like the only sane conclusion available, a conviction that what's about to happen is necessary, even protective, however horrifying that sounds from outside it. Planning and psychosis aren't opposites. A mind can be organized enough to execute a sequence of steps while being completely disconnected from what those steps actually mean. Apply that mechanism to everything you've just heard about Lindsay Clancy, and the picture stops looking like two unrelated sets of facts sitting next to each other. A search on Apple Maps and a search for whether a sociopath can be treated. 13 medications and 2 crisis line calls that went nowhere. A woman who could send a coherent text about dinner and, per a hospital chaplain, believe hours later that she'd kept her children safe by killing them. None of that is necessarily a contradiction. It might be the clearest possible illustration of exactly what this jury has to decide. That is the exact argument Kevin Reddington has to land with 12 jurors this week. Not that Lindsay Clancy was chaotic and out of control in the moment. That whatever control she had was operating entirely in service of a reality that had already broken. There's a second trial happening around this case, and it's not taking place in Plymouth Superior Court. It's taking place on TikTok and Reddit, and it's aimed at a man who has never been charged with anything, Patrick Clancy, the children's father. Per reporting on the online discourse around this case, a theory has circulated for years now, suggesting Patrick was somehow responsible for what happened, that he harmed the children himself, or that Lindsay's fall from that window wasn't the suicide attempt both the prosecution and defense agree it was. I want to be as direct about this as I can be. There is no evidence supporting any version of that theory. None has been introduced at trial, by either side, at any point in 5 weeks. Patrick Clancy has cooperated with investigators since the first day of this case. He was called by the prosecution as their very first witness. Even Kevin Reddington, Lindsay's own defense attorney, a man with every incentive to point suspicion anywhere else, has said in open court that what Patrick Clancy went through ranks among the worst tragedies anyone could suffer. There's a detail from inside the courtroom that legal analysts following this trial have pointed to again and again because it undercuts the online theory better than almost anything else could. Patrick's mother, Susan Clancy, Lindsay's former mother-in-law, has sat through difficult stretches of this trial and, per courtroom observers, has appeared visibly sympathetic toward Lindsay throughout her own testimony about Lindsay's decline. Legal analysts have pointed out that if the person with arguably the most reason in that entire courtroom to be angry at Lindsay Clancy is, instead, standing behind her, that's a difficult thing for any theory painting her as a calculated killer, let alone a theory aimed at her ex-husband, to explain away. So why does the theory persist? I think it's worth naming honestly, because it's not really about the evidence at all. There are 2 stories a person can choose to believe about January 24th, 2023. 1. A mother, in the grip of an illness the people around her didn't catch in time, killed her own children. 2. A father did something monstrous, and the system missed it, or covered it up. The second story, horrifying as it is in a strange way easier to live with than the first, because it comes with a villain, someone who chose this, who can be pointed at and condemned without complication. The first story doesn't give you that. It asks you to hold the much harder idea that someone can love her children more than anything in the world and still be the one who killed them, because her mind broke in a way that had nothing to do with love or the lack of it. That's not a satisfying story. It doesn't resolve. So some corner of the internet reaches for the other one instead. Here's what's actually true about where Patrick Clancy is now. 3.5 years later, he moved to New York not long after the killings. He filed for divorce from Lindsay in February of 2024, and the two of them are, legally, no longer married, a fact this trial has stated openly in open court, which is worth knowing before you see it repeated somewhere and wonder what it means. By this past spring, he'd remarried in a small ceremony in Central Park. None of that is evidence of anything except a man who, per every account from people who know him, has spent 3.5 years trying to build something livable out of the worst thing that can happen to a parent. He's also spent that time trying to make sure his children are remembered as more than a case file. In 2024, he and his sisters founded a foundation in the children's honor, focused on perinatal mental health support. The exact kind of support the crisis line calls from earlier suggest failed his family when it mattered most. He's run the Boston Marathon for them. He and Lindsay have both filed civil lawsuits against the medical providers who treated her in the months before the killings, arguing, together, notably, not against each other, that better care might have changed everything. That's not the profile of a man hiding something. It's the profile of a man who has spent 3.5 years doing the two things grief usually asks of a person, trying to keep living and trying to make sure the people he lost meant something. Ask your questions about this case. Notice inconsistencies if you genuinely see them. That's what a jury is for too. But there's a real difference between evidence tested under oath and a theory built on a comment section, and right now, only one of those is deciding anything. So here's exactly where this trial stands, as of this week. The prosecution rested its case on August 17th, after more than 70 witnesses. The defense spent the following days calling its own, Clancy's mother, her former mother-in-law, the family's nanny, a toxicology expert, the hospital chaplain, and finally, on Friday, Dr. Philip Resnick, appearing by Zoom as their last witness. When Resnick stepped down, the defense rested too. Since then, prosecutors have been calling rebuttal witnesses, aiming to undercut the psychiatric picture the defense spent weeks building. Their first rebuttal witness, psychiatrist Dr. Avram Mack, testified that in his assessment, Lindsay Clancy was most likely experiencing a major depressive episode and anxiety, not the bipolar disorder with manic features that Resnick described. Per Mack's testimony, there's no clear evidence she ever experienced a manic episode at all, which matters because mania is one of the key markers of the bipolar diagnosis the defense has leaned on. A couple more rebuttal witnesses are expected before the Commonwealth is finished, with final testimony continuing today. And then, per Judge William Sullivan, this could all move very fast. Closing arguments are expected to begin as soon as Tuesday, possibly Wednesday, depending on how long these last few witnesses take. Each side will get roughly 30 minutes to make their final case to the jury. Based on everything both sides have built over these 5 weeks, it's not hard to predict the shape those closings will take. Per how the Commonwealth has argued every piece of evidence so far, expect prosecutors to walk this jury back through the searches, the texts, the timing, piece by piece, and to ask them one question over and over. Does any of this look like a woman who didn't know what she was doing? Per how Reddington has built his entire case, expect him to do the opposite, walking the jury through the medications, the crisis line, the voice in her head, and asking a different question just as many times. How many warning signs does a system get to ignore before what happens next stops being a surprise? Neither side is likely to say anything this jury hasn't already heard over the past 5 weeks. What closing arguments are for isn't new information. It's making sure the right pieces are the last ones a juror remembers on the way into deliberations. After that, Judge Sullivan will instruct them on the law, and given how much of this case hinges on the substantial capacity test and where the burden of proof sits, those instructions are going to be dense, specific, and genuinely difficult for 12 people to hold in their heads all at once. Then deliberations begin. 18 jurors have sat through this entire trial. Per Massachusetts procedure, that number will be narrowed down to 12 before deliberations start. And unlike some states, Massachusetts doesn't offer a middle option. There's no guilty but mentally ill verdict here. It's binary. Either this jury finds Lindsay Clancy not criminally responsible, or they find her guilty of first-degree murder. There's no room for a jury that's genuinely torn to split the difference. 12 people are going to have to land, fully, on one side or the other. And it's worth being precise about what each of those outcomes actually means, because I don't think either one is what most people assume. If this jury finds her not criminally responsible, the court will move to begin the process of committing her to a psychiatric hospital, not released, not free, but transferred out of the criminal system and into long-term psychiatric care, likely for years, possibly for the rest of her life. If they find her guilty of first-degree murder, Massachusetts law requires a sentence of life in prison without the possibility of parole. There is no version of this, either way, where Lindsay Clancy walks out of this process, a free woman, anytime soon. At one point during this trial, the jury was taken somewhere most juries never go, the actual house. Per courtroom reporting, jurors visited the Duxbury home where the killings happened, walking through the same rooms, including the basement, that they'd already heard described in clinical, exhaustive detail from the witness stand. It's hard to overstate what a visit like that does to a jury's understanding of a case. Photographs and testimony are one thing, standing in the actual space is another. And per legal analysts who followed this trial closely, the read on how it's gone so far is more complicated than either side would probably like. Some have been openly critical of the prosecution's approach, describing their handling of certain witnesses as, in one defense attorney's words, tone-deaf to how a jury is likely responding to a grieving family's testimony. Others have pushed back, noting prosecutors tend to build their strongest arguments in closing, tying pieces together only at the very end rather than hammering the same point throughout. Whether that pattern holds here is something we're going to find out within days, not weeks. Outside the courthouse, this case has drawn a level of public attention that's hard to overstate. Hundreds of supporters, many dressed in pink, have rallied outside Plymouth Superior Court more than once during this trial, raising awareness, they've said, about postpartum mental health and gaps in psychiatric care, not necessarily arguing Clancy should go free. It's a reminder that whatever this jury decides, this case has already become something bigger than one family's tragedy to a lot of people who've been watching it. And per outlets tracking the trial's reach, tens of thousands of people have tuned into live coverage on any given day. This is, by any measure, one of the most closely watched criminal trials in the country right now. Whatever this jury decides this week, I want to say something that I don't think changes no matter which way it goes. Cora Clancy is dead. She was 5. Dawson Clancy is dead. He was 3. Callan Clancy is dead. He was 7 months old, and he only got 7 of them. Nothing a jury decides this week brings any of that back. A verdict of not criminally responsible doesn't undo it. A verdict of guilty doesn't undo it either. Every person who has sat in that courtroom for 5 weeks, the prosecutors, the defense team, the jury, the judge, and Lindsay Clancy herself, is going to carry that fact with them, regardless of what happens next, because a legal outcome was never going to be able to touch it. I think that's actually what makes this case different from a lot of what usually gets covered in this kind of video. There's no reveal coming. There's no twist where it turns out to be someone else. The person everyone has spent 5 weeks trying to understand is the same person who has been sitting at that defense table, in a wheelchair, sobbing since the first week of testimony. The question this jury has to answer was never who did this. It's whether the woman who did it was, in the eyes of the law, capable of choosing not to. There's a version of this story where the internet gets a clean answer this week and moves on to the next case by Friday. I don't think that's this one. Even after a verdict, the questions this case has raised about how crisis lines screen callers, about how 13 medications from 3 different providers can be prescribed to one person without anyone stepping back to look at the whole picture, about what postpartum psychosis actually looks like before it becomes a tragedy, aren't going away just because 12 jurors reach a decision. If anything, per the family's own advocacy work in the years since, that's exactly the point. A verdict ends a trial. It doesn't end the conversation this case forced on a lot of people who never expected to be having it. And I keep thinking about the 12 people who are going to have to make that decision. Whoever they are, they've spent 5 weeks watching autopsy photographs, listening to a father's 911 call, and hearing 2 entirely different, entirely coherent explanations for the same set of facts. Whatever they decide by the end of this week, they're going to carry this case with them for the rest of their lives, the same way Patrick Clancy will, the same way Lindsay Clancy's own mother will, the same way anyone who has actually sat with this story instead of just skimming the headlines about it will. I try not to tell you what to think on questions like this one because I genuinely believe you're capable of weighing the evidence yourselves, probably better than most of the talking heads currently arguing about this case on cable news. But I'll leave you with this. The prosecution has real, damaging material, a tight timeline, coherent communication all day, a search history that raises hard questions about planning. The defense has real material too, and arguably more of it. 13 medications in 4 months, a hospitalization a month before the killings, 2 calls for help that the system failed to answer, and expert testimony connecting specific, documented symptoms to a recognized clinical picture of psychosis. This is closer than a lot of online commentary about this case makes it sound, and I think it's going to come down to whether Kevin Reddington's experts can make 12 ordinary people genuinely understand something that sounds like a contradiction and isn't, that a mind can be organized enough to plan and still be completely disconnected from what the plan actually means. We are, as of this week, almost at the end of one of the most closely watched trials in the country. Closing arguments could start within days. A verdict could follow not long after that. When it does, you'll hear about it here first. I'll be back the moment there's real movement in this case, whether that's a closing argument that changes the temperature in that courtroom or the verdict itself. Until then, Cora, Dawson, Callan, 5, 3, and 7 months old. We're not looking away from this one, and we're not going to let this become a case people remember only for the arguments about her mind, instead of for the 3 children who are the reason any of us are watching in the first place. If this case has you thinking about postpartum mental health more broadly, how common these conditions actually are, and how often the people closest to someone struggling see it before any system does, that's worth sitting with too, and it's worth talking to someone if any part of this felt close to home. Subscribe if you want to be here when this verdict comes down, because it's going to happen soon. And tell me honestly in the comments, after everything in this episode, where do you land? Not criminally responsible or guilty. I read every one.